Morning, everybody. Thanks for joining. We did a poll for those of you who were on the last one at the end of the last webinar to see what the sort of appetite would be to have a seminar on restructures and redundancies. And 98% of the people, and there were over 100 people on the call, said that yes, they would be very interested in Fiona and Hermos hosting something around restructures and redundancies. So hopefully you'll all find it useful. I'm sure you will. And I guess I think just as I don't normally give a sort of market insight, but so far, touch wood, I think our team haven't seen too many signs of the R word coming up. There's a few snippets here and there, but overall, we haven't really heard too much in the marketplace in terms of clients going down that route at the moment. Obviously, we'll all wait to see what 2023 holds. And my boss was at the CBI conference yesterday, and it was interesting that she said the main theme amongst the several hundred employers that were there was skill shortages, that there's still a massive skill shortage in the marketplace, and clients and businesses are struggling to find the people that they want. So that was my little quick market insight for you before handing over to the guys. And also just to say, I don't normally do this, but just to make you all aware that our Hayes salary guide, which some or all of you will have seen at some stage, is being launched on the 6th of December. And we've got a webinar on the 6th of December to launch the salary guide, to talk about key elements that are going on in the marketplace at the moment. So I'll arrange with Fritz to send you that invite at the end of this call. So if you'd like to join that webinar, then please do so. And I will now pass it over to both Fiona and Hermos. Thanks, ladies.
Oh, thank you, Verinda. Hello, everybody who is on the call today. We are, as always, going to give you a bit of an overview and a taster, but really want to make the session as interactive and for you to get as much out of it as possible, as far as you can with Zoom. So we're obviously giving a bit of an overview of the law, applying it to a practical scenario, as you will have to do as businesses, or potentially have to do as businesses, and we'll also take any questions. So you know, as we go along, normally Hermos and I are busy typing away when the other one's not speaking, because we try and answer all your questions in the Q&A, but it is your opportunity to ask any questions that you want. If we don't get round to them today, we will of course email you afterwards, and of course if there are any other kind of in-depth questions, then you've got our contact details. But I think this is, as Verinda said, we did the poll last time. Clearly there is an interest. We're all not necessarily seeing it yet, and I think obviously Verinda's given her, you know, insight as a recruiter. As employment lawyers, we're not necessarily seeing redundancies as of yet. However, there is lots of talk of it. We had the budget last week, and the OBR forecast in terms of unemployment rates rising, which they referred to it being more like the third quarter of 2024 and rising to, you know, near 5%. So clearly redundancies are on people's minds, but I think it's that tipping point of, for as far as we can see, and as Verinda has, you know, said as well, it seems that the focus is still on recruitment and the skills shortage, and it's when we will see that tipping point. And I think the other thing to be aware of is that, of course, during COVID, we saw redundancies happen, but then post-COVID, we have had that, you know, clamber for candidates. So there is some element of, you know, forecasting, judging what skills you need, but not leaving yourself short when we do come out of this, which we will. So lots of things to consider, and that's one thing we'll talk about on the call today, is some of the alternatives that you can think about as a business without necessarily having to make redundancies. So first of all, I think we always start off with a quiz now, so we're going to start off with a quiz and get some interaction going. So if we turn to the first question, which is the dismissal of an employee will be by reason of redundancy if it's wholly or mainly attributable to the employer having a reduced requirement for employees to carry out work of a particular kind or to do so at a place where the employee was employed to work. Now, is that true or false? If you want to select what you think. And hopefully we'll get the results shortly. So true, that is good. 95% said true, 5% false. So you're all familiar, you're obviously all reading the Employment Rights Act at night. It's section 139, which sets out when or what the definition of redundancy is. And essentially it is 3 types of situation: a business closure, a workplace closure, or a reduction of the workforce. So that does amount to a redundancy, that definition. Right, number 2, the temporary closure of a business or workforce would not give rise to a redundancy situation. Do you think that's true or false? And we've got 51% saying true, 49% saying false, and it is false. The wording cease or diminish within the definition, that means either cease or diminish permanently or temporarily or for whatever reason. So that is false. So it would give rise to a redundancy situation. So I'll now hand over to Hermos, who's going to run through the next couple of questions.
Thank you, Fiona. Good morning, everybody. I'm Hermos in the employment team based in Leicester with Fiona. And we're going to carry on with the quiz questions. So if we can go on to the next one, please, Tom. Hopefully this is one that's not going to be as difficult to fare. So employees with less than 2 years service are not entitled to a statutory redundancy payment if they are dismissed on the grounds of redundancy. Let's see how we fare on this one. Yes, yeah. So that's it. I think we seem to know that 2 years is the magic number when it comes to most things in employment law, actually. So, you know, unfair dismissal rights, statutory redundancy payments. So absolutely right. You need at least 2 years continuous employment with an employer to qualify for the redundancy payment. There are lots of calculators out there on the government website, but we know it's based on age, length of service, and weekly pay, and that is capped, the weekly pay at 571 per week currently. Thank you very much. Next question. So where an employer proposes to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, it has a duty to firstly inform and consult with appropriate employee representatives or a trade union, and it must notify the Secretary of State. So is that true or false? What do we think? Yes, overwhelmingly true. It is true. I think sometimes this can catch people out because we more or less have heard about, you know, duty to collectively consult when there's more than 20 redundancies within a period of 90 days or less. But the notifying the Secretary of State is not something that everybody's always too familiar with. I don't know if that's your experience, but essentially that is something that comes hand in hand with the strict sort of statutory process that is required to be followed when there are redundancies. exceeding 20. And typically there are sort of various, as I say, stipulations depending on how many people are being made redundant. So if it's between 20 and 99 employees, there is a consultation process of at least a minimum of 30 days required. If there are 100 or more employees being made redundant, then there has to be a 45-day period of consultation with appropriate reps or a trade union if it's recognised. And coupled with that, there's also the duty to fill in it's called a HR1 form, which should be sent to the Secretary of State, which is the Business, Energy and Industrial Strategy Department. And interestingly, as I say, we're not going to cover it all in detail here in this question, but clearly there are strict processes that need to be covered, and there are fines up to £5,000 if you don't notify the Secretary of State, and 90 days gross pay per employee if a proper consultation process isn't followed. So it's one just to bear in mind that if you are going through a collective redundancy process, and that's 20 or more, that you really do need to have a look at that in more detail to make sure that you're strictly complying with all the rules. Okay, thank you. The next question. Yes, an employee who unreasonably refuses an offer of suitable alternative employment remains entitled to a statutory redundancy payment. Is that true or false? Yep, wonderful. That is correct. It is false. So here, what are we talking about? We're talking about the scenario where, unfortunately, we're at the stage where you've gone through a redundancy process, and at the end, you found that an individual is going to be made redundant. At that stage, it's normally appropriate, when they're at risk and you're going through the process, to consider suitable alternative employment. In fact, that's something we are going to talk about in a bit more detail later on in this session. In terms of the statutory redundancy payment, then, what the law does say is, well, actually, if a suitable alternative role is offered before the employment ends, and that it's due to start within 4 weeks after that employment termination date, and as long as it's suitable. So what do we mean by suitable? Well, it's got to be something that the individual can do, so it can't be something that they haven't got the skill set to do. Pretty much on the same salary, same benefits, you know, the package as a whole is no less favourable, something they can do. That would tick the box as being something that's potentially suitable. And then you kind of have to see, well, actually, okay, it might on paper be suitable, but does the employee have a reason that they say makes it unsuitable for them for any reason, and for which they don't want to accept the role? And in these situations, what we're looking at, well, it's the situation where they may have family commitments, or, you know, caring responsibilities, or something which their health, something doesn't work in this new role that they're saying, well, actually, this role isn't suitable for me. And those are the things that would be considered as part of whether a role is suitable or not. So if indeed there aren't any of those sorts of issues, and it is, for all intents and purposes, a role that is more or less equal to their current role, with no other issues or challenges from the employee in terms of their ability to accept, then they wouldn't be entitled to the statutory redundancy payment, and they'll just continue in the new role. So that's really excellent. Thank you very much. And the final quiz question for today. This is an interesting one. A reduction of an employee's hours of work from 29 hours to 15 hours would be a change to their terms of employment. So it would be a variation of contract and not a redundancy. What do we think? Is that true or false? Oh, okay, so the jury is out on this one as well. So 49% have said true and 51% have said false. And the correct answer, it is false. So potentially a reduction in hours of work could be a redundancy situation. Now, this is, as I say, it's a fairly kind of woolly question, and clearly it's about the situation of the personal circumstances of the case, and each case is different. But in theory, what are we looking at here? The definition of a redundancy situation. So it's got to be a reduction in either of work of a particular kind is what we're looking at here, aren't we? So there's not a workplace closure, there's not a business closure, but we're looking at work of a reduction of work of a particular kind. So you're looking at the cause of the reduction in hours of work. Why are we needing to change the hours of work? Why do we need to reduce them? Is it because we're reshuffling jobs around the workforce, in which case, well, there's still the same amount of work needed, so it's not a reduction of a particular kind of work, and hence it's not a redundancy situation. But if the reduction in the hours of work is because there's actually a reduction in the type of work that's required, it could potentially be a redundancy. Now, you're absolutely right for being sort of on the fence on this, because the case law in this area is also unsettled. There are cases which sort of confirm the view that actually it can be a redundancy situation, and there are other cases of equal standing that have been decided in the opposite fashion, where it said actually it's not a redundancy situation. So all we wanted to do here really is to flag that it could potentially be seen as a redundancy situation. It does need to be looked at on its facts, but it's not always, it's just to sort of plant the seed to say a change in hours or terms aren't always necessarily a variation of contract. It can also be seen as a redundancy, so it's just something to bear in mind. But thank you very much. That was very, very helpful indeed. I'll now hand over to Fiona.
Yeah, so we're just going to give you a bit of an overview in terms of redundancy, which, given some of those answers, I think you may know, but it's useful to have a refresher. So we've already talked about the types, the definition of redundancy and what we need to be looking for. That is your starting question whenever you're in a given scenario where it might be very obvious that it's a redundancy situation, there is less work, we need less employees, or you might be closing a site. But we've got to look at, number one, do we meet the definition of redundancy as set out within the Employment Rights Act? So that's where it's wholly or mainly attributable to either ceasing or intending to cease to carry out the business for the purposes the employee was employed to do, in the place where the employee was so employed, or where there is this reduced requirement. So that's your first question. Does it fall within one of those three scenarios: business closure, workplace closure, or is there a reduction in the workforce? And then the next issue is looking at numbers, which obviously Hermos has already alluded to, the magic number being 20, because if it's under 20, then we can individually consult with the employees about our proposals. However, if we are looking at a proposal to dismiss 20 or more at one establishment, then there is that duty to collectively consult. And I should say that's one establishment in a period of 90 days or less. And the reason why it's so important to be mindful of that duty to collectively consult is because the stakes are very high if you don't get that right. There can be an award of up to 90 days pay per employee where an employer has failed to inform and consult. So it is important to identify that. And where we collectively consult, we're going to be collectively consult with representatives. So it might be that you have to go through an election process if you don't have a recognised trade union, or you don't have employee representatives who are elected for this purpose. So that's very, very important, because one of the first things I would do with the redundancy exercise is really map out, once we're satisfied we meet that definition, is we map out the timeline and the process, and collectively consult. Obviously, if you've got to elect employee representatives, you've got to factor that in. Also, you've got to inform and consult at least 30 days before the first dismissal. So that's a minimum, but a lot of employers will, if time permits, that is the absolute minimum, we'll be factoring more time in for that. And as Hermos said, we've also got this duty to notify the Secretary of State on form the form is called Form HR1, at least 30 days before the first dismissal. And if you're making in excess of 100 employees, those timescales of 30 days increase to 45. So you would inform and consult with the appropriate employee reps 45 days before the first dismissal, and you would notify the Secretary of State using that Form HR1 45 days before the first dismissal. So just look at your numbers and consider whether you are, stepping over that 20 threshold, and there is that duty to collectively consult, because you're going to have to factor that into your timeline. Another key part of the whole redundancy process is looking at alternatives. Now, that's at the very, very outset and throughout the process. So whether you are going through an individual consultation process, if you've got less than 20, or even if we're collectively consulting, we'll always be turning our mind to whether we can avoid redundancies. And particularly, when we're consulting, it's consulting at a formative stage. We should have an open mind, because as part of the consultation process, employees will be proposing, possibly alternatives, ways around this, and we need to have an open mind to that and consider whatever is proposed. So the types of things that you might be looking at here are, well, is there alternative employment? Can we factor in reducing the number of compulsory redundancies we have to make? And that might be by restricting recruitment, reducing overtime opportunities, perhaps not renewing the contracts of contractors, reducing the use of agency workers. They're all steps that could take that will help in terms of those cost savings. It might be asking for volunteers for redundancy. It could be asking for volunteers for early retirement. It might be using layoff if you have that provision within your contract of employment. But note that there will be a guarantee payment if you do lay off, and in some cases that can raise an entitlement to a redundancy payment. Could you reduce hours? And I suppose that's my point in terms of looking back at COVID. And the redundancies or the different alternatives businesses looked at. We're in highly unusual times. Businesses saw a drop off, or we were obviously grappling with furlough, but can we look at some of these alternatives so that in terms of future planning, we're not in a situation where a lot of businesses are now, where they've got that shortage and they're scrambling to recruit. So they're always worth, and we should consider those types of alternatives as we go through the process. And of course, whether we're collectively consulting and then individually consulting, or if it's under 20, we'd just be individually consulting, we've got to make sure that we follow the correct procedure so that we minimise the risk of any potential unfair dismissal claims. And that means identifying pools and identifying what the appropriate pool is, and we're going to come on and talk about that. And that's very much for the employer to determine, but I think we've got to show that we've turned our mind and considered who should form the basis of a pool. We've got to consult with those in the redundancy pool. We've got to apply objective selection criteria, and we've then got to look at suitable alternative employment. And that's something that we will map out. Again, I think there's lots of preparatory work when you're looking at these sorts of exercises in terms of mapping out timelines, the documentation you're going to use, applying your mind to the pools, the selection criteria, and then actually putting that into practice. And finally, remember that, as Hermos has already referenced, employees who are made redundant with 2 years qualifying service are entitled to a statutory redundancy payment, which is based on their years of service, their age, factored into a multiplier, and then weekly pay, which is capped at 571 at the minute, and that goes up every April. So the maximum redundancy payment is around 17,000 at the minute, unless you have an enhanced scheme. So that is your whistle-stop tour of the key component elements of redundancy. We could talk about redundancy all day, but we thought it'd be useful to then apply that within a practical scenario, because ultimately that's what you potentially might be faced with. So if we go on to the next slide, we have our case study. So we have company A who wants to restructure, as it has 5 supervisors. You can see the operative supervisors there, who are performing a role that is very similar to its 45 production operatives, but on much higher pay, so not providing value to the company. Instead, what it's going to do is remove the supervisor role from the structure entirely, and then have 3 operations managers. So previously in the current structure has 1, but they're going to move to 3 operations managers, removing those operative supervisors. And the 3 operations managers then will each manage a shift, 6 till 2, 2 till 10, 10 till 6 a.m, which they didn't previously do. So the new operations manager roles will be more hands-on compared to the current operations manager role, and that will involve direct supervision of the production operatives rather than overseeing the department generally. So there is clearly a shift in the functions of that role. The current operations manager works 9 till 5. The supervisors currently work shifts in line with those proposed in the new structure, and all affected employees have more than 2 years service. So we're effectively getting rid of those operative supervisors. We're going to have 3 operations managers instead, but they are going to be more hands-on, and they're going to work shifts rather than their 9 to 5. So if we go on to the next slide. So, I mean, this is the scenario that Hermos talked about earlier. If we just kind of park the change in the hours, given the change to the duties that are proposed to the operations manager's current role, do you think this would be a redundancy situation? So we've got to factor in some of the considerations that Hermos talked about earlier. And is there a diminishing requirement of the business for employees to carry out work of a particular kind? And, you know, there's that typical scenario, same amount of work, less employees. It might be less work, less employees, or less work and same employees, where there might be a change in job function or a reduction in hours. So this could easily, you know, that question in the quiz about the change in hours, could this be seen as a change in hours? But we can see here that there is a change in function as well. And what is the cause of that? And we've got to look at what is the cause of that. And that it is because obviously we're getting rid of, there's diminishing requirement for the operative supervisors. But I think on the surface, this is one of those tricky areas, because it may not necessarily look like there is a reduction in work. And that's why if you do get this kind of scenario, you've got to look behind it and see, is there a particular kind of work that is ceasing or diminishing as a result of the changes? And in this scenario, I think there is, based on the operative supervisor's role, which is then leading to a change in the operations manager's role. Now, just some considerations as well are, this is taken from the viewpoint of the employer, and that implies a commercial judgment. So as long as we've turned our mind and have looked at, you know, what our priorities are as a business, that is sufficient. We don't need to demonstrate that we've undertaken an objective assessment of, you know, part of the market drying up, etc. But it's for us to make that decision and show and be able to demonstrate to a tribunal, in the event it's ever challenged, that it's a genuine reason for the dismissal. Also, we're looking at the work and whether work of a particular kind is diminishing, and that's a focus on the business, not necessarily on the employee. So again, we're looking at a diminishing number of supervisors, and that in turn is having an impact on those operations managers. So the next question is, of course, is there a suitable alternative for that operations manager? And assuming the salary is the same, I think, yes, this, you know, the role that is proposed is potentially suitable alternative employment. Yes, there is a change in duties, but I think if the salary is commensurate, there would be an argument to say it is suitable. I think if there is a reduction in the salary, then there's potentially an argument to say that it's not suitable alternative. I mean, the practical solution in this scenario, I think, would be to speak to the operations manager and seek their consent to the change. And they may well change, they may well agree to those changes, and that would be the simplest way in terms of removing the need to enter into a redundancy consultation if we can agree. Because of that operations manager's seniority, I think it's likely that the company can justify the fact that he wouldn't necessarily be in the pool with the supervisors. So that is on a practical level how I would deal with that scenario. So if we go on to the next question, if company A were considering changes to the operation manager's working hours only, and there were no change to duties, would this be a redundancy situation? And again, this refers back to the quiz and that murky area that Hermos highlighted. But changes in shift patterns only will not, so, you know, going from core hours to shift hours, as we've got in this scenario, would not constitute a change in the kind of work. And there is a case that looked at that, which is called Johnson versus Nottinghamshire Combined Police Authority. That case held that if the overall requirement of the employer for employees to do certain work remained the same, but the individual employees required to do it change, this may constitute a reorganisation as a result of a change in terms and conditions. So you would hope to agree that change with the employee. If they didn't agree to it, there would be obviously you'd offer them that you terminate their existing contract, offer re-engagement on new terms, but effectively their dismissal would be for some other substantial reason, namely reorganisation. So that kind of highlights that point that Hermos mentioned before, where you're determining whether a change in hours could amount to a redundancy, or where it doesn't, it amounts to a change in terms and conditions. And importantly, in this scenario, that individual would not be entitled to a redundancy payment because it is a change in terms and conditions. Okay, I shall hand over to Hermos.
Thank you, Fiona. Thank you very much. So just moving on to the next part of the case study is looking at the supervisors, of course. So Fiona focused on the operations manager and the intricacies of how you deal with that. And now we're moving on to look at the supervisors. Clearly, that is where we've got this underlying issue of, well, they're being overpaid for doing essentially a glorified production operative role, aren't they? So it's about getting around that and working out how best to deal with the transition from what we've currently got to the proposed new structure. So the 5 supervisor roles, we've said obviously that they're going to be removed from the structure, and instead we're going to create, we've already got an operations manager, but we're going to create 2 additional operation manager posts as well. So in this scenario then, would we say that this is a redundancy situation in respect of the supervisors? Well, clearly, yes, there is, because what we're doing is we are removing all of the supervisors in that we're saying, well, we don't actually need this many supervisors to do the role that they are doing. And that clearly falls within the reduction in the kind of that particular kind of work section of redundancy. So the next question, what process should company A follow to ensure the best candidates are placed into the newly created operations manager role? So essentially, this is what we're looking at, isn't it? How best do we deal with a situation where we're not just doing a straightforward reduction in headcount in a particular role, but we're actually creating a new role. And so the available roles aren't ones which supervisors are currently doing. And in this scenario, it might be that the usual approach of pooling everybody together and doing a scoring exercise might not be the best way forward, because actually these supervisors haven't been tested, have they, in the operations manager capacity that we're looking for. So in this scenario, the best option is probably going to be one which includes some kind of interview process, a competitive interview process, so that the supervisors are given the opportunity to apply for the role of operations manager, as opposed to automatically assuming that one of them or the two of them will be right for these new roles. And that would be entirely reasonable to carry out, and actually favourable, because what we're doing there is we're looking at, as we said, and as the owner has mentioned, a key component of the fair consultation process, which is, are there alternative roles? How can we avoid redundancies? And clearly this is a red flag to say, yes, there are potentially roles that might be suitable. But of course, bear in mind, we do have a managerial role here, in that there are, it's a position of responsibility, and it's not the same as what the supervisors are currently doing. And so there might be elements of the role that do need to be tested by way of an interview process. So in terms of next steps, that would be potentially a better approach than assuming that all these supervisors can automatically just switch from one role to the other. The next question, can company A recruit externally if the company does not wish to place any of the current supervisors into the newly created roles? This is a question that we get quite a lot from clients, actually, that they already kind of have a judgment in their minds as to, well, the current people on the ground are unlikely to be able to do the role, and they may be right, but of course that's potentially a step too far without actually testing the process. So it is likely to look like a predetermined outcome if, on the one hand, you're potentially making these redundancies, or have to make redundancies, when there are suitable, or there could be suitable roles available for them in the business. And that again falls into what the owner was saying about, are we doing everything that is possible to avoid the redundancies and keep individuals within the business, and opening up the recruitment process externally before considering the internal interview process is likely to look like there's a predetermined outcome. So that is how I think we would sort of want to move forward in this strategy, if it was a scenario where we're not sort of reducing numbers. Thank you very much. If we just move on to the next slide. So yes, now we're going to be looking at, well, how the consultation process differ if, instead of having the 3 ops manager roles that were newly created, the company simply chose to reduce its headcount of supervisors from 5 to 1. So it's not a scenario of removing the supervisor level, but just downsizing it to 1. And this is in a situation where the supervisor role isn't the same as the production operative roles. And the reason why we mention that is because, well, clearly if the roles were similar and it was just a case of having too many supervisors and production operatives, that would entail a process of including the production operatives in any potential redundancy exercise. Here, what we're focusing on is, if the supervisor role was a unique role within itself and there was just a straightforward reduction in headcount, what would be the considerations that we would look at as part of that consultation process? And this is where we wanted to talk about selection criteria, because we know it's one of those areas that you get so many calls on, and it's sometimes hard for employers to pin down the various factors that should be looked at when trying to come up with a selection criteria, when you're trying to essentially choose between these competing individuals for that one role. So that is the first thing, really, isn't it? So to think about pooling these individuals together, these 5 supervisors, and starting the consultation process. So announcing to them all that this is what's going to happen. There's going to be a reduction in headcount, explaining the business case, the reason for it, and placing them all at risk of redundancy. As part of that process, what is very important, and we've had a few questions already on consultation, is how much do we involve our employees in the selection criteria and the factors that are taken into account. And actually, there is a lot of cases on, even a recent case, which is called Mogain and Bradford Teaching Hospitals NHS Trust. This is a 2022 case. It was only, judgment came out last month, where there is a big emphasis on including the individuals at risk within that sort of the determination of the criteria to be used, the selection criteria. So what would be the best approach is to come up with the factors as the employer, and then sharing those criteria before any scoring takes place with the employees for their consideration, because ultimately we may not have considered or factored in something which an employee might say, well, actually that negatively, disproportionately impacts me more than anybody else for a reason. The whole idea is to create an even level playing field. That's the idea. So if there is a criteria that you include that is going to single somebody out very obviously before you've even started the consultation process, then clearly that's goes against a fair, open consultation process. And that was the case in Mogain that I've just mentioned. So there were basically a series of nurses that were on fixed term contracts. So it's slightly different, but they were all on fixed term contracts. And the only criteria that was used to determine who should be at risk was that this, it was the length of the fixed term. So whose fixed term contract was going to end the quickest. So they thought the one that ends the earliest will be the person that is selected. So it's the case of Mogain versus Bradford Teaching Hospitals NHS Foundation Trust. It's a 2022 case. And of course there, it was glaringly obvious because they used that one criteria to determine who should be, at risk of redundancy. And there the tribunal said clearly, you've lost the battle before you've begun, because you've already selected or devised a selection criteria that's going to show or identify the person who should be selected without any meaningful consultation. So what the employer did, which I think quite a lot of employers do, is devise they kind of work backwards, so they kind of know roughly where it's going to land, devise a criteria that might sort of get them there, and then actually the consultation becomes about, well, are there any suitable vacancies? No, job done. And actually this was that very case where the employment tribunal said that's not good enough. So kind of getting to that outcome before even the scoring, and then just looking at alternative vacancies isn't enough for a fair dismissal. It's not meaningful. So there is a real emphasis on involving the employee at an early stage so that they can actually influence the outcome of the decision. That's what this case said. And again, the other point to mention here is that, so what criteria should be used? Well, hopefully we all know that the key thing here is objectivity, impartiality. So factors that will try to reduce the subjective element of judgment on the part of managers that will be more likely to be criticised than things that are objectively factual. So, attendance records, disciplinary records, performance based on objective appraisals. Then if they're in a sales role or in a role where there are measurable targets, looking at are targets met. Those sorts of considerations. Length of service, what do we think? I know that was very popular. People love length of service. A lot of employers love that one. And there's been kind of varying degrees of hesitation with people using it or not. Why don't we use it, or why don't we like using it? Well, length of service naturally comes with it. There's elements of age that are involved there, and it could lead to sort of questions of, well, is there a discrimination argument here, indirectly discriminating against somebody that's younger, potentially because they haven't acquired, they're younger, they haven't been there very long. So normally length of service can be used as long as it's part of a range of factors. Sometimes it's used as one of those, it's like a tiebreaker type factor that could be used, that, you know, if you've got people that are equally scoring, that might be the deal breaker. They're the tiebreaker. But that is a consideration, isn't it? Are there any protective characteristics, anything that we need to think about from a discrimination perspective as well? So it's not just objective factors, but also, are there things in, say, attendance records that we shouldn't rely on? Say, somebody who is absent because of a disability, pregnancy related, family friendly leave related issues, they all should be taken into account and excluded. So anything that will, again, as I say, I'm going to use the word again, an even playing field, that will change the even playing field or distort that, should be taken into account. So the process then, well, who would normally do this, undertake the scoring? Well, typically it's a manager, somebody who's close to the individual, that, you know, in the team, that knows them all the supervisors. So perhaps the operations manager in our scenario would score the supervisors here. Although obviously query, because it's kind of, you know, they're involved. If we obviously get them into their operations manager role and they are on board with the process, then that's absolutely, they agree to their new shift patterns and they're all on board with the new terms, they would be probably the best person to lead with this scoring exercise. And typically you would want to have the scores checked and reviewed or scored by at least 2 managers. And I know that's not always practical, especially with small businesses, but having at least HR input or a second opinion is always very, very helpful to show that there has been an objective scoring, because you're very likely to get some criticism of the manager by an employee who says, oh, actually, I've been underscored because the manager doesn't actually like me, or they told me off 2 weeks ago, or, you know, something that could prejudice the scores. And it's always very good to be able to have that second person to review the scores. So that is really what I wanted to talk about in terms of that initial, the scoring, involving employees as part of the scoring, involving them as part of the decision and discussion around how can redundancies be avoided, as Fiona mentioned, what other alternatives could there be. And typically, you would expect there to be at least 2 consultation meetings before any dismissal. So the first one, just to sort of discuss the scores, other ideas, are there any vacancies, all of those sorts of things. And then the second one to regroup. So if there are any questions from the employee, to address those, to go away, you know, to consider those proposals, investigate, come back with the findings. So you'd expect two levels before you reach a decision, potentially to make the individuals redundant. And of course, before we get to that stage, another consideration which I think is worth mentioning is bumping. I don't know if that's a term or a concept that any of you have come across before, but essentially bumping is a process whereby if you have some individuals that are at risk of redundancy, it's a way of trying to save them by making somebody else in another team that isn't redundant. So bumping this person that's at risk into their role and making that person redundant, even though their role obviously still exists. And the reason why you might do that is if the individuals that are at risk are particularly valuable. So if they have a lot of skills and experience, they're long serving, you know, and you potentially may have other junior employees that may not be as critical to the business. There may be an argument there that actually this individual, the senior individual, might be willing to take a pay cut or you know, a transfer of role to go into another role. So it's just about considering whether that is suitable, and it's not necessarily always going to be the right thing to do. But what we do need to have as employees is a paper trail that we've at least considered it, because there are cases out there which says it's something which employers should actively consider. Although there's no kind of stated duty to do this, it points towards fairness and unfairness, and clearly over the years the case law has moved and evolved to really make that quite obvious, that employers should be considering whether there are any suitable bumping type scenarios with the individuals at risk. And actually it's even more critical to consider if the employees themselves have suggested it. So I had a case about 6 months ago where, again, it was a redundancy situation, and an employee said, well, before the compulsory redundancy process, there was a voluntary redundancy exercise. And as part of that voluntary redundancy exercise, an individual applied for voluntary redundancy, but the employer decided that actually they didn't want to make that individual redundant because they were a good employee, and they didn't need that individual to, they wanted to retain that individual. And when subsequently the compulsory redundancy process opened, they then, this employee that was at risk said, actually, this other employee, she wanted to be redundant, so why don't I just go into her role, and she can be made redundant as she wanted. And the employer didn't do that. But at tribunal, it was found to be unfair for that reason, because actually, although things had changed and that individual's role was very much still there at the time, it was a bumping scenario, and the tribunal said, because your at-risk employee specifically requested to be considered for that role, and that other individual had seemingly wanted to take voluntary redundancy, it should have been considered. So it's being alive to those unique circumstances that might arise as you're going through the process, and even decisions where you sort of have these discussions with other employees, they may then come back to form part of a subsequent consultation process. So I think the key here, takeaway, is it's not a tick box exercise, and the individual circumstances of the case should be considered. Employees also should be given the right to appeal, although it's not sort of legally required. It's good practice, and actually the employment tribunals will consider it as part of the fairness of the process. So I'll now move on to the next slide, please, and hand over to Fiona.
Yeah, so the next question is, what if the supervisors are all based in different locations and the remaining role was required in Nottingham? And of course, location is one of the factors that an employer could reasonably consider when looking at the pool, but it's one of many factors. So I think we've got to look at the type of work that's ceasing or diminishing. Are the operative supervisors doing the same or similar role across all the sites? Because if they are, I think there's more of an argument to say that there should be a joint pool. Are the roles of the operative supervisors interchangeable across the sites? Is there anything particular to the Nottingham site, i.e. that you need specific knowledge or there's specific training? Have those who don't work on site previously worked there? Again, they will all be factors to consider in relation to the joint pool. The extent to which the site's operations are linked, so do they all work as one, or are they very much independent, and would that impact on the pool? The length of service, if you've got a particularly long serving member of staff, then there might be more of an argument to pull it into a larger pool. And what have we done in previous redundancy exercises? What's our policy in relation to pools? The starting point is just to, it's ultimately, and the case law has established this is ultimately an issue for the employer to determine, but they have got to show that they've turned their mind to what the pool should be, the factors to consider as part of that, and ultimately, if the pool were ever challenged, they've got to demonstrate that the band is within, a reasonable response, and that they've considered all those sorts of issues. So as I've just run through, when you are looking at your pools, I think you need to sit down and look at other potential areas where individuals might challenge and say, but actually aren't our roles interchangeable? Why can't we be considered? You know, how in what proximity are the other sites to the Nottingham site? They're all factors. And yes, you know, providing we believe that our pools that we've determined are fair and reasonable, then that will be sufficient for employment, you know, if we're ever challenged in employment tribunal. But I think you've got to anticipate what those potential challenges will be so that you can respond to employees during the consultation process. And, you know, Hermos was raising that point about, you know, the McGain case and you know, getting employees' feedback. You know, I have seen employers in the past, some may want to retain control and or they've consulted on the pools, because again, it's harder for an employee later on to challenge that if they've agreed to it as part of the consultation process. So all things to factor in. Now, one of the supervisors is currently on maternity leave. What's the relevance of this? You're probably aware that obviously if you do have an employee who's on maternity leave and they are at risk of redundancy and it's not going to be possible to continue their existing contract because of redundancy, then they are entitled to be offered suitable alternative employment or a suitable alternative vacancy where there is one to start immediately after the existing contract ends. So it's one of those rare cases where we can positively of lawful positive discrimination, and do bear that in mind. If we didn't, and there was a position available and we didn't prioritise the employee who was on maternity leave, that could lead to a claim for automatic unfair dismissal. And you may also be aware that the government are currently, I think the bill is or it's going through, it's had its second reading in October, but they're extending this right to not just cover maternity leavers but to also cover pregnant employees, so during the duration of their pregnancy and 6 months after their pregnancy. So that is that priority will be extended to cover that period. Okay, and the final couple of questions, back to Hermos.
Thank you, Fiona. So just lastly, I'm conscious that we've only got a couple of minutes, so we'll be quick. So here, Julio, a supervisor at Company A, started at the company on the 15th of October 2017. He received notice of redundancy on 30th of September 2022, and his employment will terminate on the 31st of December 2022. So in terms of working out his length of service then for calculating his statutory redundancy pay, how do we work that out? What is the relevant date? What's the end date here? Well, really, when notice is given, the end point for working out length of service is the date that the employment will terminate. So in this case, the end date is the 31st of December 2022, started 15th of October 2017. So that's 5 complete years of service, and hence that will be taken into account when calculating the statutory redundancy pay. However, the next question then, so if Julio didn't receive notice with his employment terminating on the 31st of December, but instead was paid a pylon, would that change his length of service? So in those situations, so if no notice is given, or if a pylon is given, a payment in lieu of notice is given, which would mean, well, actually that cuts short your termination date, so that the 30th of September date is the termination date. What the statutory rules say is you must add on the statutory period of notice that should have been given to him onto the end of that day, and then use that date as working out the length of service. So in our scenario here, at the point of the 30th of September 2022, Julia would have had 4 years continuous service. So you add on the 4 weeks to the 30th of September date, and that takes you up to the 28th of October. and then that is looked at as your end date for the purposes of continuous service. So that, if you look from the 15th of October 2017 to the 28th of October 2022, that again gives you 5 years. So that would be the length of service to take into account. But it's a question I've had quite often, where employers say, oh, you know, we're paying in lieu of notice, how does it work? And as I say, you add on the statutory minimum notice required to get that sort of magic number there. Thank you. And next slide, I think that is it. A very quick whistle-stop tour.
Thanks, guys. Thank you, Fiona. Thank you, Hermos. I hope you guys found that useful and insightful as always. So thanks, guys, for all of that information. I think now, seeing as we're nearly in December, we're going to give Hermos and Fiona a break for the rest of 2022. But fear not, everybody, we'll be back in January, more than likely. So in between now and then, any topics, anything that you particularly want to hear about, please do let us know. You've got my email address, Nicola's or Fiona or Hermos. Please just do reach out to us and we'll make sure that we try and make them as ever as informative to you guys as possible. I was going to say hope you have all the best for the festive season. Feels a little bit early to say that, so hope you guys have a good remainder of 2022 and we will see you all in 2023, no doubt. Thanks very much, guys.
Thank you, everyone.
Thank you. Bye-bye.